Trademark protection is national. There's no such thing as an international trademark covering all the countries of the world. This means that filing a trademark in the United States or any other country does not protect your trademark in other countries. It is important to consider filing a foreign trademark registration if your company offers goods or services in another country. Registering your mark in a foreign country gives you the right to own and protect your brand against would-be copycats and knockoffs in that particular country. This is particularly important where a brand becomes successful beyond the United States, and users outside the US see this success. They can copy and register your brand in their country and sell the same goods and services you sell unless you filed before them in most cases. In some countries, they can just register your mark to block you from registering in that country and never sell goods with it. Then they may try to sell you your own mark when you try to register it in their country. Understanding trademark law in each country is essential before using a mark outside of the United States. While in the US, trademark rights are based on use. It is more important to be the first to file in many countries. Before a competitor can steal the goodwill and brand reputation you have worked so hard to build, you should file a trademark application in countries where you plan to do business by selling or manufacturing your goods in those countries. A couple of international treaties provide special benefits for filing in other countries. For instance, if you can file an application to register your mark in another country within 6 months of the date you filed to register that same mark in the US, the filing date in the foreign country can be the earlier US filing date and not the actual date filed in that country. As may be evident, this can be a strategic advantage where the first to apply owns the trademark. Another international treaty called the Madrid Protocol allows you to extend your US application or registration into multiple other countries that are members of the treaty simply by filing a special application form at the US Patent and Trademark Office. A Madrid Protocol application is like a cluster of foreign applications filed at once, which streamlines the trademark registration process and results in what is called an international registration, though it is really a series of multiple national registrations administered through a central body called the World Intellectual Property Organization. There are presently over 100 member companies or jurisdictions in this treaty, including all of North America and the European Union. Dunlap Bennett and Ludwig maintains an extensive network of foreign associates to file and enforce trademarks in many countries around the world, and its attorneys have a good deal of experience with Madrid Protocol applications. Contact us today to learn more.